I just want to read, we're live now and we're recording. Board Member Owens is here as well. I want to read the public advisory. This meeting will be conducted exclusively through video conference and teleconference. Pursuant to Government Code Section 54953E and the state declared emergency, this meeting will be conducted exclusively through teleconference and Zoom video conference. The COVID-19 state of emergency continues to directly impact the ability of members to meet safely in person and presents imminent risk to the health of the attendees. Therefore, no physical meeting location will be available. To access the meeting remotely, you can join from a PC, Mac, iPad, iPhone, or Android device using the URL that's on the agenda and on the PAB website. If you do not wish for your name to appear on the screen, use a drop-down menu and click on Rename to rename yourself to be anonymous. To request to speak, use the raise hand icon on the screen. To join by phone, dial the number on the agenda and on the website and enter the meeting ID also there. If you wish to comment during the public comment portion of the agenda, press *9 and wait to be recognized. Okay. Shall we do a roster?
Sure. Board Member Calavita.
Here.
Chair Chang.
Here.
Board Member Leftwich.
Oh, you're on, I think you're on mute. Board Member Leftwich.
On mute. You can't hear me?
Okay, now we can.
Yeah.
And Board Member Owens.
Here.
And Ms. Saganor, I still do not see her.
Okay, we'll go. I'm sure she'll come on soon.
I'm sure.
All righty. We do have quorum. That's correct. That's
Yes, we have quorum.
right. So are there any questions or comments on the agenda?
I move we approve the agenda.
Excellent. Someone second?
Second that.
Okay. Any objections, questions? No, not seeing or hearing any. Agenda is approved. And public comment. Let me pull up my timer really quickly.
Well, I don't see any members of the public.
Oh, okay.
Chair.
Okay.
I think people are watching council.
Oh, that's right. Yeah, thank you.
Or the Warriors game.
Or that. Yes, good point.
That is most likely. Okay, no public comment. Old business, jump right into it. So receiving feedback from the BPD, Lieutenant Montgomery, on complaints filed with IA only, Section 3, consider language from staff regarding tolling Section 2 and N. Would this be a good time, Lieutenant Montgomery, to review some of the BPD concerns and perspectives on the regulations that you were going to, and I know you may not have had time to engage with the chief on?
Yeah, so I couldn't get the chief's time or enough of the chief's time because she's kind of knee deep in reimagining right now. So I couldn't get enough calendar time to really go through it with her. I sent out some feelers and gotten some information back, but I don't consider complete from IA about your other queries. So I was going to kind of ask to push that item to the meeting on the 4th. Is that right, Kathy?
Yeah.
Okay.
Yeah, I just want to be organized and more succinct, and then make sure I get all the feedback I'm trying to track down.
That makes sense. So on the 4th, we'll chat about it, and it would be really helpful if you're able to have like a list, if that's what you feel is the best way to present the information or requests prior to that meeting.
Yeah, I'll see what I can do. It's about sort of finding time, and I gotta have the time for the staff work after I find the time with the chief and the right folks. So
Okay.
it'll depend how it falls. So we'll see.
Great. Okay. Thank you. At a minimum,
I'll do my best.
yeah, I
Otherwise,
appreciate that. At a minimum, we'll see you on the day of that meeting to review.
That's right.
Thank you. Finalized draft of proposed regulations. So let's jump right to it. There were a couple of emails earlier in the day, and I would, those were regarding basic grammatical, typographical type of stuff. I think that can be taken care of without conversation. Is that okay? Or
Yes.
okay, good. So let's remind ourselves, where were we at the last time?
Can you see my screen?
Yes.
Okay, here we are.
Okay, great.
Kathy, what section is that?
But just for context, yeah, we're in 2C.
Okay. 6 of 22, and Kathy very conveniently wrote start here on April 21st. 2C4, sworn officer schedule. Okay. I don't have any comments here. Do you guys have comments here?
No, I don't have anything on this page.
I had something on 7.
Okay, and let's take a quick look at 6A before we're going to go down chronologically a bit.
Yeah, this is flagged for discussion.
That's right.
This whole idea about what role the board has in investigations and what does subpoena power extend to the board, and
Okay, that's right. We had talked about that before. So
Right.
7.
okay.
Yeah. So the point that I've kind of raised throughout all of this is that I think there should be parity when it comes to requirements of the complainant and the officer. And so 7 says subject officers and witness officers must appear for interviews. And then it talks about, the rest of that. And my suggestion was to say complainants, subject officers and witnesses must appear. And then the last sentence, instead of an officer who is unavailable, should say individuals who are unavailable. But I don't know what the current practice is regarding notice to complainants. But it just seemed to me, as much as possible, these kind of things should generally be applicable to the complainants and the officers.
The reason it's different is because they're not on equal footing in that the officer is subject to discipline. We also have a provision, you probably remember, that if complainants don't make themselves available,
Right.
then staff can ask the board to close the complaint.
Right. I did see that.
Yeah. So the 9 days requirement, this is something that comes from the PRC regulations and have been met and conferred about. So
There's something though about how much notice is given to a complainant.
no, I mean, we could, if they want to say, I'll come in this afternoon or I'll come in tomorrow, then they'll do that. So we have a lot more flexibility, and I don't want to lose that with our complainants.
Yeah.
And they do have to, they must participate. So the complainants must participate. And the risk, if they don't, is that their complaint will not be investigated or the investigation will not proceed. So I feel that we have enough sort of impetus or motivation for complainants to come in. And again, I don't want to put a time frame that we have to give them notice, because we would like that flexibility. Nobody's complained, because it's completely, we work it out with the complainant. We don't say you have to come in tomorrow. We say, when is a good time for you to come in? And we don't serve them with a notice. It might be a phone call, it could be an email. It's much less rigid. And the reason is because for officers, this is part of a proceeding that possibly leads to discipline. And so they need all these rights. All the rights.
That's fine. That's fine. I get it, and we can move on.
Okay.
Okay, good. Makes sense. Next, any questions about that? No, that would you got a good description. Oh, Ms. Aguilar is here also, by the way.
Oh, okay, thank you. And so is Mr. Norris.
Oh, hello, Investigator Norris. So we are down to 8. Anything else here? Conduct of interviews, exercise of constitutional rights.
I think we had actually gone through this before because
Yeah.
mine was added. And I don't know if, I realize it doesn't really have a heading, so I don't know if it should be part of, did we mean for it to be a second paragraph of 8? I don't remember.
You
I don't
mean,
think necessarily, but
I'm sorry, Director Lee, are you referencing starting from when possible? Or are you talking about 9?
No, I'm
We're
talking about 9. See,
Okay.
9 looks, I think we added 9 and it doesn't have a sort of a heading.
Sure, I see that. So you're wondering if she has to have a second paragraph, a second, yeah, of 8.
So I'm wondering, did we, I don't remember, did we intend to make this part of 8 and did it just auto number or,
Yes, it looks like part of 8,
okay,
part of 8. It's
Yeah,
about constitutional rights.
okay,
I
Yeah,
agree.
let's,
all right.
yeah, let's just do it as the
I
second
suggest-
paragraph.
I suggest to break it up just because 8's so large and just take exercise a constitutional right. Make that the title and make it number 5.
Well, but exercise, we've got constitutional rights here. We've got Fifth Amendment.
Oh, okay. Then throw it all in there.
Okay,
Okay. Yeah, we did talk about this, and it has POBRA and has a footnote to the government code there as well, which is important to have. I think it looks good. Any comments? You should flag that now, though. The pre-hearing complaint disposition, administrative
some-
closure.
I have
Yes.
something on Roman numeral 5, little 5.
Okay, let's go to little
Mhm.
5.
Yeah. I think
Failure
that
of the
we-
complainant to cooperate. Okay.
I think we should add a last sentence there just to make it clear. This provision, parens 5, not the whole section, but 5.
Okay.
This provision does not apply to informal complaints as discussed in section whatever it is when we get there. Because about complainants required to submit to an interview and all that stuff doesn't apply to informal complaints.
well, we're
Okay.
in a section titled formal complaints.
Right.
All right, if you think that's fine.
I
I
think
just
that's
want to,
fine.
I just think, I hope it'll be perfectly clear that that's not,
So can you scroll up really quickly, Director Lee, to it's a pre-hearing complaint disposition, administrative closure grounds.
well, but
And then-
the
Yes,
whole
but the
section is.
whole- We're in section 2.
Right. Is under
So,
formal
and section
complaints.
2 is called formal complaints.
Okay.
Okay,
Okay. I think that
That's
makes
fine.
sense.
Okay,
We want to describe the context a bit too for accessibility purposes, because not everyone can see the screen when they watch the video, and there's no captioning here right now unless you speak it out loud. So
Okay.
I'm just, every now and then it may sound repetitive, but I'm just gonna like really quickly overview what we're talking about.
okay.
So great.
I have
And
something on 4, right above the provision we were talking about.
okay,
In
Numeral
C or
4?
D?
D1A Roman numeral little 4.
Okay,
under grounds again. The
Yeah.
complaint is moot, including but not limited to situations where the subject officer's employment has been terminated or where the complaint has been resolved by other means.
Yeah, and so I just want to ask, I'm not sure what the answer is, but when I read that, I guess I'm thinking, are we sure that an officer's termination renders the complaint moot? I mean, I understand that the board's recommendations may change, but a civil lawsuit could still proceed. So I'm wondering, is it a jurisdictional issue? Like we just don't have jurisdiction over someone who's no longer an officer?
That's right.
But I guess my
you couldn't-
thinking is,
Yeah.
we would want to know, and maybe there's some other way to record it, but what if somebody just keeps, it has a lot of misconduct and is fired? Wouldn't we want to know that? I mean, anyway, again, I just kind of pose it to the group because it seems weird to me. If there's a viable complaint and then the officer is just fired, then we just is it nothing then, or is it tracked somehow? Anyway, so that
The
was my
department
question.
can no longer obligate the employee to show up or participate because they're not an
Right.
employee anymore.
Right.
So there's that aspect. They will disappear from the proceedings.
Plus, it's also a personnel hearing to potentially implement discipline. If the person is no longer an employee, you can't give them discipline.
Right.
And if
Right.
the complainant is on a complaint is on an individual officer, and that officer is no longer employed, there's nothing the department or anybody else can do to discipline him. So there's no reason to have the hearing or
Track it, do we track it otherwise? Because I know Kathy, you do the annual report. And it just seems like it still is an important fact just for us to understand the universe of complaints, but again,
I mean, we do in annual reports, well, I haven't done one yet for the PAB, but for the PRC, we had a category of, we reported disposition closures. And the reason that a complaint was closed, either, it made it through a hearing or it was administratively closed. And I can't remember, I think we might have had one, I can't remember, that we had to close because the officer no longer worked for the department, but it's certainly something that can be spelled out in a report.
to me, it's different if they're terminated versus retired or, they moved or something just because that,
Well, I don't know if we would know. I guess if it were reportable under SB 1421, those kinds of cases, the more serious cases, then that would be public.
Okay. Director, you want to remind us about SB 1421 in terms of reportable?
1421 is the law that opened up certain types of records, disciplinary proceedings to the public. And so the initial categories were whenever an officer, not just disciplinary records, investigations or, incidents. So officer involved shooting, a death, a sustained finding of sexual harassment or dishonesty. Those are disclosable. And then there's a law that went into effect at the beginning of this year that broadened the categories, and I just don't know them off the top of my head.
that means you can state the identity of the person, right? Because we're not talking about.
Yes.
I'm not talking about stating the identity. It's just, to me, it's relevant to know that there was administrative closure because the person was terminated.
Mm-hmm.
I mean, just seems to me like something that the city and the public and we would want to track.
I agree.
So let me ask this question. What are the rights of someone who's been terminated? Because the reason why I ask that question is, my guess is this won't happen very often. And so if you have one officer terminated that 1 year and we say we close the complaint because somebody was terminated, it's pretty easy to figure out who it is. Right. So my question is related to what rights does that terminated officer have? And potentially are we stepping over those rights?
Well, obviously, I as a director wouldn't issue a report that divulged any information that was not public. So, but I believe, and Lieutenant Montgomery can correct me if I'm wrong, but I think that an officer terminated for one of those categories in 1421, I think the name is disclosable. Was that your understanding?
But we're not terminated for that. I'm not talking about
that.
Oh, what are you talking about? I'm sorry.
Any reason.
Oh, well, if they're, no, then we can't disclose the name.
No, but
we're not talking about.
But my point is, if you have a complaint about an officer and they're terminated,
yes,
my guess is the department doesn't terminate officers that often.
That's correct.
If you put this in a report that we terminated a complaint because the officer was terminated, it would be pretty easy for anybody to figure out who that was without naming a name, because how often do they terminate?
Well, assuming that
are we stepping into somebody's,
assuming that the termination is known, right?
I was gonna say, I was reading the charter today, and I think the charter says that this board has purview over sworn members of the Berkeley Police Department. And so when somebody doesn't become a member, does your purview sort of end, whether it was sort of convenient or not, or to the sort of whole process? The other thing I think that does address the concern, though, that you bring up, Julie, is that Senate Bill 2 is being implemented now, which is tracking officers who for certification or decertification through California Post. And so anybody that we terminate, we will be reporting to Post, and Post is still working out all the ins and outs of that rule system, probably in a committee just like this. Right now, they're actually just launching implementation on SB2 right now.
Okay.
To track kind of that concern of like, we left this hanging and it was unfinished business and they
Right.
left our organization and went somewhere else.
Right.
But in all cases, it seems to me that we're finished with this provision in the
Yes, I
in
think
the regs, so we can move on. That's a
can move on.
conversation
I think that's right. Thank you.
for another day.
Yes.
Thank you, Board Member Calvita. So we're down to what number here? Director Lee, are we on the right?
yeah,
Yeah.
I think
Down to
so.
procedure. Failure to complain to cooperate. I think we've talked about this all before. Is there anything in this section from small 5 through E2
You know
on the
what?
page here?
Can we get rid of by mail? I think this is a
Good idea.
leftover from the old days before email.
Okay. And it's okay just by electronic mail?
I think so.
Yeah, because you do send the board members hard copies as well.
Right.
Well, we don't have to
We probably
specify.
would do
don't-
both, actually.
I don't think we have to specify. We can just end it by shall be notified.
They'll be
Yeah.
notified.
Right.
Okay.
And we'll use the appropriate means,
Okay, that sounds good.
the appropriate and acceptable means to the chief. So, I mean, we have our protocols with the department, so.
Yeah, that makes sense. How about 2E12? No contest response.
Nothing.
I didn't have anything there myself. At E1 and 2 and 3, initial submission and consideration of investigative findings and disciplinary recommendations.
No, we spent a lot of time on
It's
that
not-
already.
Yeah, talked about the 60 days, et cetera. Okay, good.
Right.
We're now
Talk about standard,
categories of findings. We talked about unfounded, not sustained, exonerated, sustained. We tweaked the language on that. We're now
Wait, can
shifting.
I'm sorry, Chair, can we just
Sure.
go back quickly to no contest? I just want to check something.
Okay. A subject officer who accepts the allegations of the complaint as substantially true may enter a written response of no contest at any time before the director submits their findings and recommendations to the board under section 2E1. If the subject officer sends a no contest response, the director shall so notify the board when findings and recommendations are sent to them.
You know, I wish I had I'm not in town, but I wish I had the PRC regulations, but I thought the purpose of this was so that the officer can avoid a hearing under the PRC regs. And this doesn't really get to that. I mean, what are we trying to do here? We're trying to say if the officer is not contesting these allegations, we want to short circuit this process for him or her. But we're not offering anything here in the way this is written.
Right.
I think that was the point. I wish I had my PRC regulations in front of me. I think that was the point of this no contest response section in the PRC regs. So what are we offering here? What are we doing?
Okay.
Doesn't it just say they shall be notified? So the last sentence, the director shall notify the board when findings and recommendations are sent to
Yeah,
them.
but what do we do about it? Do we then recommend discipline or what?
Oh,
I mean, we got a situation where the officer is saying, I am not contesting these allegations. I accept them. So
right. Doesn't the director still go through the process of making findings and recommendations?
well, that's the
so
question.
that's the question. I was looking for my PRC regs and I can't seem to find any, so.
Well,
So
it does,
Yeah,
it does say here that findings and recommendations are going to be sent from the director.
So the implication is that they were made, right?
Right, you're going to notify the board when you give us your findings and recommendations.
She's just notifying us that there was a no contest. I don't think that there's no finding and recommendations because the person said no contest.
Well, then why does it say?
No,
when
will be
findings-
though, right?
It says when findings and recommendations are sent to them. It makes it sound like there's going to be findings and recommendations.
Yeah.
But we don't have to do that. I guess I'm just asking, what is it that we want to do? What is it that we want to offer the officer? The officer saying, I accept these allegations as they are. I do not contest them. Do we want to have the director and the board go through this process as it is? Or do we want to say, fine, you accept them and let's short circuit this somehow?
But
Right.
we still need findings and recommendations, even if the officer says, I give up.
Well, maybe we need recommendations
Right.
and not findings. But we're sending them at this stage. I think the board would still want to know what's going on, so we're not gonna. So we either have to do it in the F&R stage or make up some other process.
Ms.
So-
Aguilar has her hand up.
I think you would still want findings because it says this could happen at any point, right? So you might have already done a whole lot of investigative work on this,
Mhm.
and you would have input from the complainant and so forth.
So
So
if
it's
somebody
not-
complained about me and they said, he was discourteous to me. And I went back and looked at it and I said, oh man, I had a bad day. I was discourteous. And I didn't want to go through the rest of the process. I could just say no contest, at which point the finding recommendations would then go to the board and then you would forward them to the chief.
Yeah.
I
Or
think
if you agreed
so.
with them,
Right,
if the board,
right. And-
if the board agreed with them.
Right. It's
Okay.
also often the case that there's several allegations and the officer might say no contest to one or two of them, but not all of them. So we still need to do findings, recommendations.
Well, maybe
Right.
this needs to be revised. Only apply when the officer accepts all of the allegations.
Well, why
Well-
couldn't it apply to if?
Yeah.
Partial.
No, in any
One.
case,
Yeah,
Excuse me?
it could still apply to, why couldn't it apply if it's just one of several? Then we,
Because
just-
it's,
Partial.
all this says is.
because
that-
it's not short circuiting the process. You still have to go through the whole process with the other allegations. This is,
it doesn't say here that we're short circuiting.
Right,
Right, we're
it
not.
says it's
oh, I
still,
know it doesn't say that, but I think that's what the intent was under the PRC, if hopefully I'm
Oh,
remembering.
okay, but Byron, we're in a different process now, and I think.
No, I get that. I guess I'm just trying to figure out what is the point of this?
I think so the staff doesn't have to waste any time doing
Right.
the full investigation.
And the,
Just
and
wrap
the
that
board,
part up and then present it to the board that the officer said pleaded no contest. Or-
right, and it
Deals
saves,
with a possible scenario, right?
it
This could
saves the
happen,
board
so we
time
need to
too.
address it.
I guess I was also wondering what is the incentive for the officers to exercise this option? Because I know how it's going to benefit the board, but what is the point of this?
It would seem to me that it would allow the officer not to have to come in to be interviewed.
Well, only if it's
For-
all the allegations.
Oh, right. Or at least the interview would only focus on certain allegations and not the ones that there was no contest to.
Maybe
So
they
it would-
just, right, they
it
would
save
not have to
something.
talk about a mistake they made that they don't want to rehash.
Yes.
Right.
Yes, and they may not want an interview and they may not want a hearing.
Yeah.
So what are we offering? Just no interview or no interview and no hearing? I'm just trying to get us to think through what is it that we're offering?
I think it would depend on what it was.
Mhm.
I think
Okay.
if somebody comes in and says, let's say there's only one allegation. And they say there's no contest, I did it, I'm falling on the sword. So at that point, there's no point of interviewing, there's no point of doing an investigation because the officer is essentially saying,
Yeah.
yes, I'm
Yeah.
falling on the sword. And so then it just goes through the process after as if they were sustained, I guess.
Right,
And just move through it. That way you don't have to go through all of this other stuff.
Yes, and that's what I'm trying to get us to, because the way it's written, it seems like there could still be a hearing when the officer no
If
contest.
there's more than, if the officer has more than one allegation, is not saying no contest to all of them, then we're still going forward on the other ones.
What's your issue with it, Byron? I'm trying to understand. Where
Just
you're-
making sure that as it's written, that it, let's see, 1 second. Well, the way it's written, it doesn't indicate that the board won't have a hearing if the officer offers a no contest.
That's right, because there still could be a hearing if there's other allegations.
So maybe
are-
this is just when the
contested.
officer offers a no contest. Maybe this only should be applicable when it applies to all allegations.
No.
Why?
Okay, so let me make a suggestion. I hate to say this, Byron, but you're not going to be here, and all the rest of us are on the same page. So I think I think we just move forward. I'm serious. It looks like Lieutenant Montgomery is shaking his head. He seems like he gets it. The rest of us seem like we're on the same page.
I'm gonna miss you,
So-
Byron.
We're gonna miss you, Byron, but we're gonna run over you on this one.
Okay, and I'll be signing out now.
No, we
He is
want
on
your
vacation, don't forget.
feedback, but I think all the rest of us are on the same page.
If
Right.
I think it's right.
That's fine.
No,
Okay,
yes.
we can move on
That's
then.
right.
It sounds like it's
Board Member
flexible
Owens,
enough
none
to
of-
manage what you're
Nobody else
referencing.
seems to have a problem.
We can move on then.
Okay.
Okay, good.
Thank
Thanks, Byron.
Thanks. Okay, so we're at E 1, 2, and 3 are on the page now. I don't have any comments on these. Does anybody else? Okay, so let's move on to page 9. Now we're at C. We have exonerated, sustained, which we've also reviewed with the categories of findings, and we're also on 4, recommendation of discipline and level of discipline. So no comments there.
Something
What
on
decision?
F4, unless somebody has something before that.
F4 on under which number? You mean 4F or
On
F4?
page 9.
We're on E4.
Yeah, section 2, Roman numeral 2, big E,
Right.
number 4. Oh, you mean below?
Do
Oh, you
have
mean
some-
above
I was
this?
just moving ahead, but I don't know if
Oh,
anybody has
okay.
something.
Okay.
So can I ask a question about this number 4 right here, recommendation of discipline?
Uh-huh.
Is that happening? When you recommend a sustain, are you also giving us a recommendation of discipline?
No, because it's only for these
Oh,
cases that I was just talking about.
okay, that's fine.
Yeah.
Yeah.
We haven't had any of those serious cases alleged. Complaint,
4, was it 421?
categories of
wasn't it?
misconduct
Yeah,
alleged. So I
Okay.
have not had to recommend discipline.
okay.
I just
And then,
want to appreciate that for a minute.
Yeah, no,
Let us all appreciate that for a
Yes.
minute.
I think that's what Lieutenant wanted us to do.
we're appreciating it and marinating it right now. It's very good. Okay, now number 5, board decision.
I know I have-
Upon, yeah,
Go ahead. No,
go
I
ahead.
have an alignment issue here and I'm not gonna deal with it right now. I see it.
okay, you'll address it later.
Yeah.
When there's a board decision and there's a notation here of a very complicated issue from March 22nd. The board may request that ODPA staff conduct further investigation as needed.
We're not going to talk about that. Right?
Yeah,
We've
we've already talked
that.
about this.
We're gonna let it, I saw Lieutenant Montgomery put on reading glasses that means he, which I've never seen before on him. It means
He's getting
looking at this very
serious
carefully.
now.
Yeah. Yeah, this is gonna have to go before the full board. It's a complicated issue. Okay. Anything else here? We're down to F. I think board member Leftwich, you wanted to look at F4.
Yeah.
There's a scheduling, a hearing, et cetera.
Yeah, F4 is obligation to serve unavailability.
Okay.
And I guess, so the third sentence, if substituted within 7 days of a hearing, the subject officer retains the right to challenge the board member for cause. And I'm just wondering why that shouldn't be the subject officer and complainant. Because the complainant could challenge a panel member, right?
So let me just read this really quickly for
Okay.
public members. Board members must serve on roughly an equal number of hearing panels each year. If a hearing panel member becomes unavailable, they shall be replaced by another board member, and notice of substitution shall issue as soon as possible. If substituted within 7 days of a hearing, the subject officer retains the right to challenge the board member for a cause. And that's the language that you're referencing. The notice of challenge of a substituted board member must be made at least 3 business days before convening the hearing. The hearing will be continued until the challenge can be resolved. So you're
Yeah.
asking why wouldn't they add the complainant?
A complainant does have a right to challenge.
Shouldn't that be and complainant, subject officer and complainant retain the right?
Yes, I think that's reasonable.
I thought we chatted about that. Maybe it got lost in the.
I don't remember, but I agree.
Yeah,
that
I
makes
don't
sense.
either.
Okay.
Has that always been that way where the complainant could challenge the hearing panel?
I think so.
The second has her hand
Should
up.
be able to, right?
I
Maybe it
found-
wasn't spelled out, but certainly it's possible the complainant says that here, that person's biased.
Yes, I found that further down in section 2GB procedure, where it talks about the officer or the complainant may file a challenge. So to make it consistent with what it says in that section, the complainant should be mentioned here as well.
Okay.
Yes.
Okay, thanks.
Okay.
That's helpful.
All right.
Great. Let's go on to the next. We're down to 5, effective continuance, 6, notice of hearing, and 7, hearing packet. Kathy does have some language here with Kitty regarding asking the city attorney if a complainant can be entitled to more materials regarding the hearing packet or to redacted materials in alignment with Penal Code 832.7. The complainant shall receive a hearing packet without information protected from disclosure by state law. So we're gonna that's gonna be one of a number of questions we may flag for the CA. Anyone have questions on this section? Board Member Calavita, you're muted.
I'm wondering if Kathy has had a chance to ask any of these questions.
No, what I'm doing is I'm gathering them up. and
Okay.
In
I'm
one
going to
document,
ask
okay.
them- Yeah.
Yeah,
That's helpful. That's more efficient. It may
is.
take them some time to get back to us.
They're still completely swamped.
of course. As are we.
Yes.
Okay, great. How about G, board member impartiality recusals challenges?
I have something under GA, the last sentence, they shall hear all viewpoints. Here is not exactly what people mean by that sentence, I think. It's vague. I would replace that with shall consider all evidence presented at the hearing, or shall consider all viewpoints or something.
I like your suggestion, Kitty. I think that makes sense.
Okay, so shall consider.
I'm okay with
Okay.
consider, but I wouldn't want to get rid of viewpoints.
Okay,
Because I think
consider
that's a
then.
little different from evidence.
Yes, it is.
Okay.
Yeah, viewpoints is different. Yeah.
Should it say both? Should consider all
That's what I was,
viewpoints and evidence presented?
I'm fine with that. What do people?
Yeah, I
think?
like that too.
All viewpoints and evidence.
Okay.
Yeah,
I don't think we need to say at the hearing because there's evidence in the hearing packet too.
right.
So just, and evidence.
Right.
Yeah,
Oh, yes, all
Good.
evidence is covers everything.
Sounds good.
Do we need to, you think we don't need to say all evidence presented by DPA staff?
I
It
think
says all,
all evidence,
All
not just
evidence.
presented by the staff, but also what we hear at the panel.
right.
Okay, all right.
Okay. Thank you.
That's good.
All right, so now moving on to GBC. No member hearing panel should publicly state an opinion No board member with a personal interest or the appearance thereof in the outcome of a hearing shall sit in the hearing panel. It's kind of conflict of interest type of stuff. C, no board member with a personal interest or the appearance thereof in outcome of a hearing shall sit in the hearing. Okay, we just reference that. There's
We went
familial
through all
relationship,
this.
witnessing events. This is fairly straightforward, I think.
We went
are
through
there-
all this too.
Yeah, we
gone
did go
through
through all
this.
this. Yeah, I don't think there's any comments or questions that I see or hear from previously. Also, and I'm not seeing any now.
The one
I just had something and it's more of a technical thing. Just, I don't know why we're repeating. We've got
exactly.
yeah, we say what examples of personal interest, and then we say the exact same thing under 4. So it
So
just
when you
seems really,
scroll to 4. Yes,
Okay.
Okay.
I would replace this section with a board member. This is basis for challenge. A board
Okay.
member who has a personal interest or the appearance thereof in the outcome of a hearing as defined in section GC
Oh, that's what you're
shall
saying. Okay.
not sit on the hearing panel, period. And then
So
all the
after
rest,
hearing,
get rid of it.
get rid
okay,
of the
so-
rest.
so after hearing, add in as defined in section
As defined in section
G3.
G,
E1C, right?
D1C, yeah. G1C.
D1C.
G1C.
D1C is where we define it all.
Okay,
Right, right.
Okay.
and then-
Shall not sit in-
then
and cut out personal
the-
interest.
And then cut out A through D.
Whoops.
okay,
Excellent.
I like that.
Yep.
Okay, great. Now down at procedure, within 7 days from the date of mailing the notice of confidential complaint hearing. Any comments on this section? There's 1, 2, 3, 4, 5 on the screen.
Write something a little 4.
Okay, a little 4, if the board member agrees, the director of their designation will ask another board member to serve.
So to me, that was a little vague. So if the board member agrees that the challenge is for good cause, right? Because I was looking, it seems a little vague, agrees to what? Like what board member?
Agrees to be replaced or agrees that challenges for cause? Yeah,
Yeah, agrees that the challenge is for cause.
yeah.
Okay, does everyone agree with that? Board member agrees that the challenge is for cause?
So
Agrees to the challenge?
Even better.
Yeah, I kind
Agrees
of like
not-
that better. I
no,
was-
Good
what
challenge.
happens if the board member doesn't agree, but they really shouldn't be? I mean,
Yeah,
why
that-
would you put that power in the person's hand who were saying, hey, there's a problem? Oh, yeah, there's no problem, but to me, you're giving the wrong person the power to make the decision.
Okay,
But 4 says if they agree and 5 is if they don't agree, right?
Right.
Yeah,
So I think we have
And
it
it's like
covered.
no contest. It's like, you're right. I do have a personal interest.
Right. And then,
Okay.
and the
First
next
is
one,
I do not have a personal interest.
okay,
so 4 should say, if the board member agrees with the challenge.
Or I would say that the challenge is for good cause.
That's the language in the next section, so that would be parallel.
Right.
Yes.
okay, maybe that's better than if it's parallel. Agrees that the challenge is for a good cause. Everyone okay with that?
Yep.
if the challenge is for good cause. Huh. That or two?
what?
What?
Agrees
Should we-
to,
Is it, are
Agrees
they
that-
agreeing to the challenge or are they agreeing that the challenge
Agrees.
is,
Agrees that the challenge is for good cause.
I think that's better than agrees to the challenge.
Right.
Okay.
Either way.
So we're asking
Yeah.
a board member to recuse themselves and they just agree to recuse themselves? I mean,
Yes.
that's
Yeah.
a more simpler way to say it.
Yeah, I think that's better.
Good idea. So if the
Okay.
board member agrees to recuse themselves, is that what you're saying, Dan?
Yeah,
like
then
that
the
better.
DPA
Yeah.
will assign another
Okay.
board member.
that's good.
Yeah.
Oh, yeah, that's much better, Dan. Use some scenes.
Great, that looks good. So are we off to the other sections?
Yeah.
I've got something in 5. We have a reference to a BOI halfway down there.
Oh, yeah.
Special BOI, okay.
So that should
I'm not-
be,
Meeting of the other two I'm going to say hearing panel members.
Yeah, yeah. And then we have, for the challenge to be granted, both board members must agree the challenge is for good cause using the clear and convincing standard. I would just say it's for good cause. We don't want to talk about we don't want to talk about a standard of proof here, do we?
I think you should have a standard.
I'm pretty sure this is from the PRC regs.
Right. That's what I figured, but
Okay.
When we were using clear and convincing.
right.
Well, I mean, I get Julie's point. Do we need a standard?
I don't think so.
I think you do. I mean,
Well,
why-
we haven't been using it before, like earlier in this paragraph, we haven't been using it.
The only reason why I say you need a standard is because you want to make sure that in all hearings, anytime there's a challenge, that everybody uses the same measuring stick. That's the only reason why I'm suggesting.
Mhm.
Couldn't it just be by consensus? We all, I mean, I don't know. Then you just need to get into definition.
Well, there's only 2 board members, so they would have to agree. So you have to have unanimity in this particular situation.
Right.
So
I'm-
I agree with Cheryl that you need the same yardstick here.
Right,
The
yeah,
same
kind of
as-
have to,
The same as
Okay.
what, Kathy?
For any challenge, across challenges, not that
so
we
you're
have
using the same
a
standard.
great
Okay.
number,
Well,
but
then we need to
yeah.
insert it other places where we talk about challenges. We haven't mentioned it before.
We
well,
only talk about the
this-
standard of proof when it comes to,
right, this is the decision point. And we're saying this is the standard you need to make, you two hearing panel members, when you're deciding on this challenge.
Okay. Let's keep it then.
Yeah, I'm fine with that as well.
And what if they disagree, the 2 of them?
Right
If
there in the
there's-
last sentence, if they disagree, the challenge board member gets to serve. So they have to agree.
Okay,
we can't have a clear and convincing, we can't reference that. We haven't defined that anywhere.
well, it's
So-
one of those things that
It's
is.
a legal standard, but we could
Well,
define it, but
I
it is
don't-
a
I-
standard.
I mean, I don't like referencing it, but if we're going to reference it, we need to define it just like we defined the other.
Preponderance.
Yeah.
So like we throw it up at the front in the definitions then?
If we
Yeah.
want to keep it here, I would.
I'd prefer to put it here just because it's the only place.
Yes, I think it's confusing to put it in the definition,
Exactly.
given
So
that we
would-
used to use it.
A 1 sentence definition, or probably not a footnote, right?
Probably not a
we want to
footnote.
avoid.
How about, let me make a note here to just add it. I mean, we had it in the old, I don't have the PRC regs. And I can't remember if it was there, but I'm sure there's a definition somewhere.
Yeah.
So
Okay,
I'll
you could
flag
probably-
this.
Okay, just like a 1 sentence, I'm sure you can pull something up
One
online or
sentence,
through the
yeah.
PRC, yeah. Which is obviously a higher standard than preponderance. Okay, any more comments on this? I think, we want to keep moving on. It's 12 of 23. At the special meeting to hear the challenge. I don't have any here. All parties will be allowed the opportunity to present arguments, witness testimony, and answer questions under oath. Okay, and down to 5 and 6. Replacement of board members. I think it's fairly straightforward, right?
Yeah,
I think so.
Tolling of time we went through too. And continuance we went through pretty closely as well to make sure the language wasn't confusing. Pre-hearing
I had a question
continuance.
about 3 procedural issues. Are we there yet? Sorry.
Kathy, what is your comment here?
You know, this
For
is
newly discovered
old, and I
evidence.
I forgot. I didn't get rid of it because I couldn't remember what this was about.
We addressed it.
Did we do this?
I think that's related to if the board requests that the staff goes back and does a further investigation, then there may be potentially new witnesses or evidence. And I think that's what this was related to. But the
Right.
question is whether or not we can even request that the staff go back and do an investigation. So I think that's what this is related to.
That makes sense.
I remember that.
So
I can tell you that
Okay.
question about going back and doing an investigation is a pretty big point of contention. Because it's happened once already, and it was a major issue for the people involved.
Okay, thank you.
What?
It happened this year?
When there was findings and recommendations that were kind of rejected, and then it was sent back for investigation to the DPA, like a second or new investigation. It was a major
No,
issue.
no,
Here.
that was an administrative closure that the
Right, that's the one I'm
board
talking about.
refused to close. So we hadn't completed the investigation.
Okay.
But Kathy, maybe the comment in
Yes.
the margin should be if there is such a thing, you need to add new language there, re-notice regarding notice. I don't know.
That's what I put in this parenthetical, if further investigation is authorized.
Yeah, good. I can't see the side
Oh.
comments. So,
Okay, so
yeah,
I
good.
added to my comment to
Yeah.
tie it to that. If
Okay.
if further investigation is authorized.
So I don't have anything on that page.
I just had a question about 3 procedural issues, because I'm just wondering what those would be. And if it's
The-
helpful to give examples of that, because I couldn't think of what that would be.
This has
Well,
come
the
up.
kinds of questions we've gotten in the past, and I'm thinking about the subject officers, is about our process, the process of the Board of Inquiry at the time. Just questions about how we're proceeding with the process. I'm just trying to think of a more specific example. Can you?
Yeah, I know this is.
Yeah,
But it does
come
come up.
Well,
Yeah,
this
it
is
has.
less about asking questions than it is having some issue that they want to raise, some kind of procedural.
Objection, right? Some
Yeah.
objection potential.
Yeah.
Maybe it should be procedural objection. Even then, I think one came up about the process wasn't, that papers weren't served, they were given to a receptionist or something, and I'm thinking, was that what this is about? And so I guess
That could be one.
would it be a concern or an objection?
probably objection, right?
Well,
I
but
don't know.
concerns covers more ground.
Yeah,
Issues or objections?
yeah, maybe.
Sure. And then I
Sure.
think we can leave the section that way.
I think so too. I mean, I
Okay.
don't think
Yeah.
the regulation should be required to,
As a practical matter.
Yeah.
Like in the case of that objection that was raised about the not getting notice,
Right.
Mhm.
that was almost 7 days, and they were saying we didn't get notice in 9 days. And so they would be beyond the 7 days when they're actually potentially making the claim about not getting notice. So
Mhm.
the 7 days could become, I don't know,
Yeah.
logically need flexibility depending on the situation.
Right, yeah, that's true. I mean, the objection was raised at the hearing, so,
Raised at the hearing, right?
but I mean, I think the point is that if things could be worked out, the point is so that things aren't left to be dealt with at the hearing, if possible.
Yes.
Should we say if possible?
Yeah, probably if it's not going to be a rigid requirement.
Yeah,
No, we should shorten the time. If you say possible, you're just weakening the whole section.
Right.
well, how about instead of saying shall, put should? Because we know from working on other policies that should is a little less rigid than shall.
And you prefer that and just instead of just, I thought,
Just
Dan,
begin-
you were proposing shortening the time that they had to submit the
Well,
issues.
but this would allow,
Provide flexibility, right?
right,
Yeah, I think you might just run, especially on timing questions, you might run into questions that need more than 7 days, or less than 7 days. Or something, we might bring an issue after 7 days has passed and because it's about timing.
Right.
So
And
should
should
does
is-
sort of fix some of that.
But should is still kind of loosey-goosey to me.
So I think the trick is that you're trying to get an issue you can resolve before the hearing, or that might cause a hearing to be rescheduled, to be
Right.
brought to your attention soon enough to do all that
Exactly.
rescheduling and whatnot, or deciding or looking for advice.
But how about if we just said as soon as possible?
Yeah, like should, because I think should is not, it's not firm. It's
Yeah.
saying
Yeah.
should. So, I mean, if somebody comes in shorter than 7 days, and it makes sense why they did it in less time, then I think we just accept it. We're
Mhm.
saying they should do it. We're not saying they have to. And
Yeah.
then we're not really tying it to a specific number of days because we don't know when they discover this procedural concern.
right.
Right.
So we're
That makes
saying,
sense to me.
so I think when they bring it to the staff, then, they're saying, hey, I didn't make it for the 7 days, but here's why. I think the staff can make
Yeah.
the decision as to whether or not, okay, that's reasonable.
I think
Yeah.
that takes care of
That's
it.
flexible.
Yeah, let's do that. That gives flexibility for on the practice side of the investigation, implementation side. That sounds good to me. Everyone okay with that?
Yeah.
So are we,
Cool.
Cheryl, are you saying we leave should?
Yeah.
Yeah.
I thought, Cheryl, you were saying you didn't think it was firm enough also.
No, I said leave should because
Leave
should
should.
gives
Okay.
flexibility.
We're in agreement.
Okay, all right.
Thanks for checking though, Byron.
Can you
Thank
tell I was in a bar an hour ago, but go on.
Great. A pre-hearing submission of questions. Any questions about that?
Went through that
You
before.
talked about,
Yeah.
you added this, I think.
That's right. Now we're in a hearing procedure.
Kathy, just the small thing about consistent underlining, so 4 needs to be underlined.
Yes, you know what happens sometimes is I'll underline it and then the next time I open it up, it goes
Oh, it
away.
goes away.
I swear I've been underlining the same things over and over again.
That's funny. And I have a bunch of little things that I will put in an email.
Yeah.
Okay,
Just because I don't think we need to take our time, but it's good to point them out.
okay.
Okay. We're through 4 here, hearing procedures 4. Good cause. Down to good cause or failure to appear at complaint hearing. We have kind of standard stuff, doctor's note, obituary. Statute on the schedule meeting, special meeting date to hear the request. At the special meeting, requesting party will have the opportunity to present their case to the hearing panel members who may ask questions of the requesting party. Opposing party may not ask questions of the requesting party, but may present their argument in opposition.
Yeah, I think we've done all this.
Yeah.
Yeah. Yeah,
So now we're down to 5, lack of full hearing panel.
Yeah,
This is
so
very-
I had a question under 8. I think
8,
we
okay.
should be,
Taking testimony at hearing.
yeah, 8A. Hearing panel members may ask previously submitted questions. I was just confused by this when I first read it.
Gonna
yeah.
add a cross-reference or
What is
something.
What
So-
did,
Oh, because we did talk
Cross-
about.
So suggested language for that.
Yes,
Hearing panel members, let's see, where does it go? I'm sorry. Well, may ask questions submitted previously in accordance with section 2.H.4.
Yeah.
That would totally clarify it.
okay, good.
Oops. Oh, there.
Submitted previously.
Oh, yeah, there's submission of questions, yep.
In accordance with 2.H.4.
There should be a letter to H.
Yeah. 4.
Okay.
And just while I have your attention,
Mhm.
number 7, just above that, the underlining was missing. Another one where the underlining is missing.
Okay, you've been through all this.
We've done this so many times, I'm confused as to what issues I have been resolved.
Well,
Nothing here.
okay,
It's later. It's under J.
okay.
Question. Go back to the first part of this. B. So it
B?
says the complainant will generally testify first. And is the officer allowed to ask the complainant, the officer or the representative allowed to ask the complainant questions? Because this
No,
applies.
We've gotten rid of that.
no, you got rid of that.
Oh, I'm gonna raise it again. I think I raised it round 1, round 2, and now round 3, I'm gonna raise it again. It's a fundamental fairness issue. We don't know what's gonna be said. The officer should have the right to hear what's being said to the panel so they can ask questions that are relevant to what's being said. Day of the hearing. It's I know there's some sense that amount of intimidation or a sense that a complainant might be intimidated by an officer is part of it. I think that can be managed by the board itself or the decorum of the meeting.
So
But I
the
think
bigger question was that the complainant didn't have the same rights. That's how this all started.
yeah,
is
it was
that
like
it was very-
you guys were kind of doing a bunch of stuff to make it seem like equal on both sides. The problem is that the officer who has discipline on the line and who is essentially defending themselves can't defend themselves adequately if they can't ask questions, if they can't respond, if they don't know what the complainant said to the board.
Right.
And
I
they're,
think we're not gonna get to this tonight. I mean, this is a bigger issue because we just disagree about it, and so we can't decide this tonight. I mean, the board is making its recommendation. This subcommittee is making its recommendation, and then we'll take it to the full board, and then obviously.
yeah, I just think I don't know that I don't know that that's
Julie.
the case. I think the first couple times we went through it, maybe that's your kind of view of it, but the first couple times we went through it, we were kind of going line by line and item by item and kind of making our wish list and our punch list. But there have been several issues that since then you've thought about in the context of fairness and procedural justice, and kind of heard the concerns and made an adaptation that doesn't cost what you're trying to affect here, or what you were trying
Yeah,
to
I
affect.
actually take it back because we were going to hear all of your concerns.
That's
We
right.
thought we were going to do that tonight. And so we're going to do it at the next meeting. So,
We're going to hear it on May 4th, right?
right. So we'll discuss it then because we know that's how you feel and you know how we feel. So we'll discuss it on the
Well, you
4th.
no. Don't say you know how we feel, because we don't all agree. So, because
Right.
this
Right.
must
We'll
be
discuss, how about we'll just discuss it on the 4th and move on
Yeah,
tonight.
I'm happy to table it, but while we're on this paragraph, I thought I'd reiterate. And I
Well,
try
the
to,
reason why I asked the question, honestly,
know, it's a
I
good
think that
question.
the one hearing that I was in, I think that the officer and or their representative did ask the
Right.
questions. So
Because
Under the
final
temporary
regs-
regulations, we are still
Yeah,
asking
temporary
questions.
regs.
That's
So
it.
why-
Like we did before.
Wait, one at a time. Cheryl, you said you thought the officer asked what kind of questions?
I thought that they asked the complainant questions in the hearing that I was in.
Mhm.
They did,
Because that's the process we have now.
right. That's the process under the interim regulations.
Okay,
Because that was how the PRC operated.
That's right.
so I'm gonna leave this alone only because I know we're gonna talk about it again. This will be like probably the third time, but we'll talk about it again. Yeah, I'll leave it alone for now.
Okay, yeah, we're gonna revisit it and we'll give Lieutenant Montgomery time to check in with the chief. So he has a full set of conversation with us.
And please keep an open mind. We did ask Lieutenant Montgomery to bring back his substantial issues that feel an issue. So please, when these come back.
Yes, that's important. Just have a full vetting of any concerns.
Yeah, I wouldn't bring up an issue that I didn't, just so you know, I'm authorized to speak on behalf of the chief. And although I don't have the complete set for you, I'm authorized to speak at this meeting on these issues. So, I mean, it's not that as though I'm waiting or I haven't discussed this particular issue.
Right.
So I just want you to know that if I'm speaking up today, I'm not deferring the ability to speak up and contribute to this important process.
Right.
Okay, sure, thank you.
So I have something on 9, maintaining order, and I might have raised this before, but again, I'm just talking about parity. So if the chairperson, second sentence, fails to maintain reasonable order, BPD employees may leave. Well, shouldn't the complainant be allowed to leave if the chair doesn't keep order in the proceedings?
I thought we discussed.
I know, but I guess I just don't remember why it seems okay. Why shouldn't the complainant have the same right to leave, assuming the chairperson, everything goes to hell?
Doesn't the
Because
complainant always have the right
this
to
is-
leave?
This
Yeah.
is a holdover from, not only from PRC days, but from the PRC days when the hearings were open to the public
Oh,
and officers were sometimes subject to being harassed or people speaking out of turn, members of the public speaking out of turn.
Okay.
So,
But it could
Well,
also happen that, well, go ahead. So now they
Well,
are.
the other thing, Julie, the complainant, if they leave and we deem that their leaving is not appropriate, we can always end their complaint. We can close their case. But the officers are there under orders
Exactly.
and, they have to justify when they
right.
violate those orders. But again, I don't know if you could get parity in this section.
I think there's some things that you're not gonna have parity. And the reason why is because this ultimately is a personnel hearing.
Yes.
Ultimately, the officer is the one that's gonna potentially could have discipline applied to him. So you're not gonna necessarily have parity on every single item in here. I understand the need and the desire to have it, but some things you're not gonna have it like this. If the officer walks out of there, they have to provide a legitimate reason as to why they did it.
Well, if nobody agrees with me, I'll drop it and I'll try to remember to drop it forever. Forever.
I think it's all right in this particular instance, not to have absolute parity.
Okay.
All right.
Okay, this makes sense to me as well. So we're at 18 now, investigations initiated by the board.
Jay, you mean?
Yay.
I'm sorry, Jay, yeah.
Okay, so this is the one that I thought I recommended last time, and then maybe I was argued down from it. But I thought that it should be its own section because this section is about formal complaints. And I proposed, or I would like to propose, that there should be an independent section that comes just before the informal complaints section, because the informal complaints then refers back to the board taking it over as its own investigation. I don't see how this fits in the category of formal complaints, which is number 2. We're dealing with section 2, formal complaints. This is the heading for this entire section. And it seemed to me to make more sense to move it. Did I bring this up before and people disagreed? I don't remember.
I think you sent it by email.
Yeah.
Oh,
Ms. Aguilar had her hand up too. Is that what you wanted to
Yes.
raise?
Yes,
Okay.
it was sent by email, and I would agree that it would make sense for it to be a separate section.
a separate section just before, well, the next to last section before, so a new section 3, Roman numeral 3, investigations initiated by the board, just before the last section, which is informal complaints.
So it'd actually be a new section 4.
It would be a new section 4.
Yeah, and then
That-
informal claims would be
That sounds
5.
okay to me, Val. I do want to check with Director Lee and Investigator Norris. Does that make sense?
I'm having a problem with that. And this is tied to a debate we were having at our last meeting about about the difference between a complaint or a complaint investigation. And it's staff's view that when you initiate a complaint, you're initiating a formal complaint, or you're saying, let's do an investigation, and the investigations are carried out under this section 2 and all the procedures that fall under this section.
Yeah, but when the board initiates an investigation, at least from my perspective,
It's not what, I'm sorry.
I said when the board initiates an investigation,
Uh-huh.
I don't think the board is complaining about any one officer. So that's why we went back and forth about the complaint versus the investigation, because the board is not saying we believe an officer potentially did something wrong. We're just looking at an incident to see if there was some violation of policy, or if the policy should be reviewed. So we're not specifically saying, and it's possible we're looking at something that citizens are concerned about. So we're just looking into it, and we might report back that, hey, policy was followed, everything was good, and we're comfortable with the policy. So we're not complaining. I don't like the fact that if the board initiates an investigation, that what goes over to the department says that we're initiating a complaint about a specific officer, because we're not.
Right. And we did have this discussion.
Yes. So what did we decide happens if staff begins an investigation and we say, oh, it looks like Officer X could have done something out of policy? Then what do we do?
And it would turn into a complaint by the board.
Okay.
Because
It's sort of putting the problem that I have with this sort of fundamentally is that it's putting the determination before the investigation.
well, that's what we're saying. We don't want to make a determination that there was misconduct at all. That's the reason we want to say that we're alleging misconduct. And it would be, and we did have this conversation, the investigation might involve requesting records. It wouldn't be, for example, and I used this example before with regard to the Altabates death. We do not know what happened. There's been concern about it by some board members and asked the staff to investigate. But that would involve not hauling people in to interview them, because there's no allegation of misconduct at first. You want to just find out what happened. So you get records from city departments and you find out what happened when the officer came. Was the man I mean, I don't even know the details of it. Was he handcuffed? Was he already dead? What, so that
There
would
have been times that the old PRC would ask for like a presentation for the chief on some topic like that.
right.
And kind of give you an update on a hot topic, hot button
Well, that would
case.
be, that would be similar to what I'm talking about. Yeah.
Well,
But
that was, but Dan, that was a presentation. That wasn't, we weren't provided records. We weren't collecting.
Right. I mean, like sometimes, sometimes that is what's being sought and it's sort of satisfactory. It's like, okay, well, tell us what what happened in this incident. And then you say, okay, I still am concerned.
right.
I still have concerns. We're gonna advise to do X, Y, Z.
And look into records. I mean, the first step might be just that, getting a presentation or just talking to the chief, what happened. It depends.
I'm trying to think of specific examples, but we've done it a few times in the last few years. Kathy, can you think any? Or Byron?
I think there was, there were people camping out at Old City Hall, like up on the top of the steps or something, and then they were cleared out, I believe. That might have been something that Chief Greenwood reported about to us.
But that's different from, I think, what Kitty's talking about. I mean, the board has asked questions of the chief or her representative during the chief's report about an incident. But what Kitty's talking about is opening up a formal investigation, Dan, like a preliminary or prelude to our complaint process. You think that's workable?
Well, it might go nowhere at all after the preliminaries are done.
Yeah, I mean, I think, handling things at the expeditious level, because, for example, there are times when, specifically really serious cases, that they get tangled up in investigative kind of constraints. It makes it harder to release information. And that, in the case of a death or a homicide investigation or something like that, it could be tied up for some time. So it seems like what could be provided, depending on the venue, what could be provided might be more informative than launching a full investigation into something where you're just like, I just don't know what happened, and we want to know if, because there is concern, because you're kind of trying to address the sense that there's a community concern, as opposed to trying to pinpoint wrongdoing.
Right.
Right.
Or a board concern. It may not, and it be started by the community. It may be that we've learned of something. But so that, anyway, that would be my proposal, that we enable ourselves to have these investigations initiated by the board. We could call them inquiries if investigations makes people uncomfortable. I think that we need to, I think that we would need to change that or add to the sentence, investigations into possible police misconduct may be initiated by the board upon a vote of 5 board
now
members.
I think, Kitty, I'm thinking now, should this even be in the complaint procedures if you're talking about this other process?
Well, let me finish. That was the first sentence of this section. Then I would say subsequent to an inquiry or an investigation, a formal complaint may be initiated by the board. And then the rest of that section about rules of procedure shall follow those for formal complaints, et cetera, et cetera. So I do think we need something here which would allow us to initiate, and of course we wouldn't initiate the investigation, but we would trigger the staff, because it seems to me that we have otherwise quite a narrow set of abilities to review, as the charter says, all written policies, practices, and procedures. So we'd be doing an investigation into a particular set of police practices or
Yeah,
incidents.
I've said this before, and I agree with Board Member Calavita. It's important for enforcement agencies in general, and I've been in enforcement agencies that are governmental and are commission based, where they have something called directed investigations or other functions where they can conduct investigations on the basis of concerns that may come up even through reportage of news. They even do, like the Department of Justice, for example, does this routinely. And if they have concerns, obviously there's some structure there for process to then potentially open an investigation, and typically call it a directed investigation, for example. I think it's important for an advisory committee of this sort to have that authority and discretion, and it's obviously it has process around it. It's not an open back door to do whatever you want. It has structure here.
I think that we need to be very careful when we do this, and that we should make sure that the charter allows us that authority.
Mhm.
I'm still struggling with,
You know, that's what should happen, and
Yeah.
blah, blah, blah. But if the charter has to allow us to have that authority in order to make that happen. So we just need to make sure that we can identify specifically in the charter where it gives us that authority. I definitely agree with everybody. I think we should have that. I think that should be part of the responsibility of the board, but I'm just saying,
Yeah,
prepared to show where that's in the charter.
I think the
I
board.
totally agree, Cheryl. And
I think, Kitty, I think the board has the authority to request records and look into anything. My only issue is we're putting in place now a formal complaint process. And
Byron,
that's
it's not a complaint.
no. These regulations, this is a complaint process. That's what we're writing. And so what you're carving out is this preliminary step. And I don't know, Dan, if you're okay with it, I'm going to leave it alone. But
So
I'm just, I'm just wondering, you have the authority, but does that need to be here? And if it is here, it needs to be spelled out what you're doing.
I had the charter concern as well. You know, the old PRC had something like this for somebody who was dead or unavailable, otherwise some kind of unavailable, in a coma or in the hospital. So I have a little bit of charter concern there. And I was kind of looking at the vote of 5 and kind of wondering if you're saying this isn't something that we'd only use in the most serious cases when the whole board agrees, and maybe you make it unanimous, or maybe you raise the bar from 5. Simple majority is pretty low bar.
right. I could agree with that and go to 6, but I have to say, with regard to the charter, I did go through it once again today and found several places, but most importantly, the very first paragraph of the charter, which establishes the purpose of the board, it says it is to promote public trust through independent civilian oversight. And this is, to my mind, foundational to oversight to be able to do this. And so, I mean, there is nothing in the thing is that the charter is one document. Let's say these regulations are 22 pages. Obviously, the charter is not going to stipulate every single detail explicitly, just like the Constitution doesn't talk about privacy, for example. But the purpose of the PAB, according to the charter, is to promote public trust through independent civilian oversight. And in my mind, this particular authority that we're talking about is fundamental.
Kitty, I'm not questioning that, but what's the title of these regulations?
So I'm on the same page with you.
What's the title of these regulations? These are regulations for handling complaints.
But we didn't have to do that. I remember raising at the outset, why are we gonna have other regulations? I didn't know why we necessarily had to be so specific in the
Sure.
title.
So let's think about this. So while they're complaints, it's also a case processing, I don't know what you call it, manual.
Go ahead.
We
I'm
can
sorry.
recap-
Never
we
mind,
can
never
recap
mind.
it to complaints and board investigations, if that makes Byron happy.
Right.
What'd you say?
Or-
Could you repeat that,
Well,
Cheryl?
no, I think what would make Byron happy is not to even put it in here.
No, I think,
To acknowledge
I think
that
we
there's
have to-
that authority to do so.
no, I think
Yeah,
we could I think the board does have the authority.
He's
Because-
wondering where to put it. I think he agrees with the authority. I think it should be in here, and whether we can change it to case processing manual or investigatory processing procedures to address in general, what would you do when you have a concern either through a formal complaint or an informal process or a investigation initiated by the board? And it's, yeah.
How-
go
We
ahead.
have to
about-
specify what other regulations are we going to be promulgating? Why-
How about this? Because we also, there's a lot in these regulations that is about the staff investigations, how they proceed. So how about titling this document, Regulations for Handling Investigations and Complaints?
Yeah, that's fine. And it's kind of
And-
generally, yeah.
And because this particular authority is in some cases preliminary to the board filing a formal complaint. But because much of this is about the investigations process, and so that covers it.
We just
Sure,
need to
and more
add it
somewhat
in the
generic.
preamble, right? In the preamble, these
Right.
regulations for handling investigations and complaints.
Well, we don't want to say investigations against sworn officers. So how about if I put it here?
So Kathy, I heard you a little while ago say that you didn't believe that the board had the authority to do these.
I'm not sure. I'm not,
We're going to be asking the city attorney, isn't one of these big issues that, right?
You could
Yeah.
ask them, Kathy, I mean, it's subject to determination in some, I mean, it's subject to interpretation in some ways, but I think if we're talking about a charter, I agree with Board Member Calavita. If we're talking about a charter amendment that came into 2022 with the purpose of modernizing the PRC into modern standards and jurisdictional review, it would be kind of odd to not have that authority. It would be counter to the intent behind modernizing. So just in that alone, that would seem to be counterfactual to the actual intent of even putting the time in to create a new charter. So I do think that having that type of this authority to do directed investigations is pretty standard to modern federal and state agencies, even with standard law enforcement authority, but also to like whistleblower, inspector general type of agencies as well that are advisory, just as this is advisory.
What do you think about raising the bar?
I think we need to be careful about talking about state and federal stuff when we're talking about the Berkeley charter. So we have to be able to point to something in the charter that supports that we're able to do it. Because if you
Yeah, I think-
don't, I guarantee you that
Someone
POA will. So we need to be prepared to point to something in the charter that gives us that authority. Not talking
Yeah.
about federal or state, and what modern, whatever. We need to be able to point to it in this charter.
Sure. So Board Member Calavita has referenced some spots I think are relevant. I also want to, do you want to reference those again, Board Member Calavita?
Well-
Also, Lieutenant Montgomery had asked a question.
One of them is the very first statement of purpose, which is about independent oversight, very broad purpose. And then subsequently throughout, under powers and duties, it talks about advising and making recommendations on all practices, police practices. And later it says under 17A, the board may review policies, practices, and procedures of the police department in its discretion. So it gives broad discretion to review.
I think that last one is particularly strong.
I do too.
Kitty, I don't agree. I mean, I'm not disagreeing with that. I just, the charter, and I'm going to say this and then I'm going to leave this alone, but the charter to me contemplates that the board does have broad authority in terms of policy and general non-complaint related investigations. The charter establishes the director to carry out complaint investigations and lays out a process for that. What you all are proposing is this preliminary step to determine before the, I don't know. I'm just not sure we're going about this the right ways, but.
There's no other set of regulations. This is what we've got.
That's part of the problem, Investigator Norris, and that's why we're changing the language, which does seem to scope-wise capture what we're describing both in formal
So what's
and
an
informal.
investigation? What's an investigation? We need to define that then, because this is something else.
So I would go back for a second and I'd say, like, for example, some boards have the right to impose discipline directly or hire and fire the chief or things of that nature that were not granted in our charter. And if you read those 3 sections that Kitty just read to us, you might say we have a very strong mandate to hold the police department accountable, including the chief. And you might extrapolate that those 3 statements made that okay here, and they're just not authorities granted by the charter.
Yeah, I see where you're going with that. I would disagree with that, Lieutenant Montgomery. I think that's a little bit more of a that would be overreach if we were to say then we have the right to hire and fire. But the discretionary language that Board Member Calavina interpreted, I just read, I think really falls in line with that notion of authority to trigger and initiate review when there is a concern, a reasonable concern.
Yeah, that doesn't go an issue for me. The issue of saying, hey, look, we want to look into this, we want to have a concern. I just see this as a 2-step potentially to looking for things for the board to initiate complaints about, as opposed to complaints, the board being the arbiter of complaints received by the DPA. See what I'm saying?
So yeah, we're saying that we think that the authority is in both areas, twofold in that manner. Both what's been received and also what can be initiated based upon concerns that it learns through either members of the public or through its own assessment of events or facts. Of course, there's still going to be a reasonable standard.
So in the past, and not clearly stated in the charter, but in the past, the board had the ability to initiate policy complaints. The board had the ability to look into things and ask questions of the chief and find out about incidents. And
so you believe that's qualitatively different from what we're naming? It may be a naming issue. We're naming an investigation.
Maybe because when we were talking about the way we've been talking about up until tonight, it sounded like the board would be initiating complaints against officers by a vote of 5. And now it's saying, well, we just want to look into this by a vote of 5, and we might ask for documents as part of our process of looking into it, or and then it's like, well, what if we see something? Well, that's then we'll make a complaint. It seems like
I would be happy to. You mentioned raising the threshold, and I would be perfectly happy to raise this to a super majority, like 6-3, for this to be initiated. Because I think we're talking about rare cases.
I don't think it's going to happen that often, but
if that's a concern.
Yeah, I think if it's important, a higher bar help. Like if you landed on this, I think a higher bar would help just manage the amount of work you're undertaking. But
so how about a super majority of 6 out of 3 then?
Because all these things also imply work at the police department, right? They imply that we're going to be doing staff work and investigation.
Sure.
And then Kitty, what is the investigative process? Because we laid out the process for the DPA staff, but what is this process that the board will engage in? I feel like we're starting from the beginning.
What do you mean? Well,
this is a whole new area that we've introduced. But so anyway, let's just get back to my initial point.
It's a new day, and yes, it'll have to be worked out. But I think that the investigations would probably involve some record requests.
But don't we have to write that here? Because you've just changed the title of the document. And now you have complaints and you have investigations. What is this investigation process?
So you know
Generally,
what, I'm gonna throw this back at the staff to define the process that the board wants. Because the staff will know, the staff should be able to put some words to the process they'll take when the board asks for an investigation. Understanding that the staff is not accusing any officer of anything, so we don't expect it to be a complaint. We expect it to be an investigation where you look into what happened.
Yeah, I just wanted to get,
folks, whatever it is that you need to do to bring the information back to the board so the board can make a decision on how to proceed.
yeah, I just
Are you
think it
saying
would
you
be,
want us to figure out what your job should be?
no, that's not what I'm saying, Cheryl. I'm saying this is something that is new. And I'm just saying, give us the staff some direction. Of course, we can go back and flesh out the details, but what is this process?
Why don't
In
we
general.
flag it? Why don't we change it to a vote of 6 and flag this process issue and move on? Can we do that?
Sure. I agree with putting it a vote of 6. That's fine by me.
Okay.
6 of the.
Board Member
so 9.
Calavita had modified this
Original.
language and I didn't get any of it. All I did was move the section.
what, I'm sorry, what didn't you get?
I didn't get any of your changes to the section. All I did was move it,
Oh,
but I did not have the
Yeah.
opportunity to.
Is the
okay,
language
so
pretty quick? Or do you
before
need-
rules of procedure, but initiating the second sentence here. Subsequent to an initial inquiry, a formal complaint may be initiated by the board.
Okay, so this is, are we getting rid of this sentence?
No, no, no,
No.
just the beginning of the second sentence,
Okay,
okay? Subsequent to an initial inquiry or investigation, a formal complaint may be initiated by the board. And then the rest of that paragraph is the same, but under letter 2, under number 2, where it says only subject officers, we've been through this section before, only subject officers there, I think you need a parens S on representative, and witnesses shall, and then I think we need be interviewed and testify. I mean, this is the normal process for complaints.
well, okay, wait a minute. If they're testifying, then we're talking about a hearing, then I think we're into a formal process, right?
This is the, yeah, so subsequent to an initial inquiry investigation.
Oh,
A
okay,
formal complaint may be initiated by the board. Rules of procedure shall follow those set out for formal complaints initiated by aggrieved parties, et cetera, et cetera. Two
okay,
exceptions to this general principle apply. Complaint or moot, and then witnesses shall be interviewed and testify, just as in the normal process.
okay. Do you want to change the first sentence?
No,
No?
no.
Okay.
That's where 5 lives, right there. Vote of 5.
Oh,
You're saying
6. We want to say 6.
Okay,
Yeah.
Kitty, did I hear you made a motion for unanimous? Do we have a second?
No,
No.
let's go with 6 for now. But again, I think it will be extremely rare, even with 5. I don't think these things come up very often, but I think our authority, I agree with Mike, I think our authority to do this needs to be explicit because it's a fundamental oversight authority.
And so that should be A, right, Kitty? Oh, is that what you were doing?
yeah,
Yeah.
I'm trying, that's what I'm trying to do, but I don't know why it's not, let's see if that works.
Just speak up.
I'll fix it later.
Okay, one other tiny little thing. In number 2, parentheses around representatives, around the S in representatives. That's it. Thanks.
A bunch of those throughout the document, so I will send them.
Okay, thanks, guys. That was good conversation.
Maybe I'm
oh.
just gonna get rid of the parentheses in both.
Another way to do it, yeah.
Oh,
Oh,
good
okay.
idea.
This looks better. This just looks less clunky.
Good idea.
Don't you need an S there?
Yeah, there's
Okay,
an
got it.
S. I got rid, I
Oh, okay,
deleting the parens.
okay.
That's like
Okay, so where are we?
So
Or
now we
we're
have to go back to page 17.
Right.
Okay.
Oops.
So just a time check, we're at 8:43. Okay, so are we at the top of evidence then?
Yes,
So we went through this very carefully too. So
Right.
I think we don't have anything unless someone caught
We have
something.
something in 4, which is at the very end of this section.
Oh, I did too. I don't know what that means.
To me,
Judicial
this
disposition.
is really important. So, and so this is vague. Either party may present to the hearing panel evidence of the disposition of a related matter by any branch of the judiciary, blah, blah, blah. So what does related matter mean? Could it be a disposition of a prior lawsuit against an officer, maybe a past conviction of the complainant for a DUI or domestic abuse, if there's a similar fact pattern?
So if I had
No.
if I had a federal lawsuit for excessive force and was found factually innocent, then this board would not be able to find a sustained finding.
Okay, well, we need to clarify this because it's not clear. I mean, I assumed it was going for something like that, but what does that mean? It could be something about the complainant also.
We're talking about something
yeah,
related
it could.
to the incident. So I
Right,
take
related
this
to
as,
the incident.
I can take this as, because we get complaints and there's pending criminal charges related to the underlying, to the incident, and then those are disposed of by the court. And yeah, it's not any issue. It's related to any charges that came.
So
What
let me
if there
use
were
a,
prior charges against an officer and the officer had been found guilty? You're saying of the incident? Because this
Right.
doesn't.
It should be more specific, but that's what that's about.
Also, if let's say I appeal to a higher authority, you sustain a finding, I appeal it to the arbitrator or superior court, and they give a finding, this board is now supposed to treat that finding as true and accept that their earlier finding was wrong. And make subsequent decisions like it based on that, right?
Oh, I don't know about that one, Dan.
No, I just think this is
Well, that's how we
really
ended up in the
important.
lawsuit in the first place, right? I mean, at the end of that lawsuit, the prior actions that led to the lawsuit, the board had to make an adjustment.
that
Well, if
dependent
there's a
on if the,
civil- What if there's
Oh,
a
go ahead.
civil lawsuit against the officer and the office, there's a case decision saying, yeah, that officer is guilty of something. So then,
They would have to accept it as, this board would have to accept that as true.
We would have to accept
And
their
if you hadn't
findings.
sustained, it would
Right.
essentially sustain it.
Mm,
wouldn't it?
yeah, I don't know. I
Yeah.
just think this one raises some issues and I don't know the rules about prior related incidents. But if we're talking, yeah, I don't know.
Does this added wording help?
It helps, yeah.
so
Dan, are you saying that the hearing panel, the board would be bound by those decisions? Because that's not what I'm seeing here in section 4.
So when I read it, I was thinking about ways in which what is identified as a higher authority than the board makes a ruling about something the board is considering or has done. So that's kind of how it was running through my head.
No, I don't.
I wasn't thinking about the complainant.
I think it
But it could be about
applies
the
to the
complainant.
complainant too.
Right.
Yeah. I think it's
Um,
just saying that the board will accept those dispositions as true, but they don't have any impact on how the board can reach its own
We
findings.
need, yeah,
It
So
may,
maybe
but
we need
it,
to spell that
yeah.
out, but it could, but we're just
It-
saying,
it
okay,
could.
we know these, okay. We
Yeah,
just
I
need
mean,
to-
if the board were sitting here and saying, you know what, I don't agree with the Superior Court judge that found that this was not excessive force. I want to sustain for excessive force. That would be the board not taking that as true.
right. But here's another example on the complainant's side. If a complainant was stopped for speeding and pulled over for speeding, and complainant files against that officer and says there was no reason for him to pull me over. And then it turns out that in traffic court, the complainant was found to be guilty of speeding. Then you have to accept those in the hearing,
Well, that's
that
interesting.
he was speeding. That's how I interpret this.
That's interesting.
So, well, it says either party, so I read it as there could be judicial
That's-
dispositions affecting
Right.
either a subject officer or a complainant. That might
Right,
be
that's my
both.
interpretation too. And are we thinking about this in the context also of potentially like prior acts that you're referencing,
Yeah.
board member Leftwich, as like a pattern or practice for a particular
Right.
officer? Is that what you're saying?
No, I don't think it
but
applies.
maybe
that
that's
way.
not related to the incident.
Right. See, I think the prior acts do not relate to the incident in question.
Okay.
Unless.
So you
you're
mean that they
talking
should
about-
not?
Right.
You mean they should not? Like,
I think they do not, unless, I guess an exception could be if there were a pattern of a particular officer interacting with a particular complainant, then you might get
Yep.
into the patterns.
and
Because
not,
we do have an allegation called harassment, which is continued, repeated.
okay, so that's very narrow. And just trying to make sure
Yeah.
everybody understand that. You're saying a specific officer specific to a particular complainant versus a specific, the same hypothetical. I'm not saying this happened in Berkeley. A specific officer with a track record of, like Lieutenant Montgomery was referencing, use of excessive force in prior incidents, not related to this specific complainant, that should not come in.
That
I
should
don't-
not, no,
I
that
don't think
cannot
that-
come in.
No,
That, that comes in at the progressive discipline level with the chief and manager. So
Not at the
chief-
investigations phase.
Right,
no,
you're gonna be looking at this one incident on its
Right.
merits. and
There are
making
some
decisions about that.
restrictions on prior bad acts in
Right.
court context too,
Right.
right? So I
And in
get that. I just want
personnel,
to make sure
and in
everybody understands
personnel
that.
law, if you walked into it saying, well, we sustained a excessive force on this guy before, so he probably did this one too. It's not.
Right, could be
necessarily just
prejudicial.
On its face.
Mhm.
Yeah, it's like letting a bias into the process.
Okay, just want to make sure everybody understand that. So are there any other questions here about this then?
I guess that fixes it, just saying relating to the incident. And
What about-
accepting the findings is.
What
true.
about the last sentence?
Right.
What do we want to do? What is it, what's reasonable? What is it that we want the board to be bound by or not bound by?
And it doesn't say bound, it just says you shall accept them as true.
And what is?
It's a
yeah, what
different
is-
thing. Yeah, I don't know.
There are cases where, I mean, I think this is probably so rare that the board will probably have to talk through the implications when it comes up and then reason through how to proceed. And it may mean that you reverse a discipline recommendation or you reverse a finding or, but I think there has to be some space to say, all of these will be different and we'll have to handle it kind of as it comes on a case-by-case basis.
yeah, and I think this is rare enough that we don't need to spend much more time on it.
Okay.
Okay,
Yeah, I think that sounds good. Any other comments or questions about this?
no,
Okay, thanks. Let's proceed. So we're deliberation and findings.
Well, okay, this was the issue I had raised before, and then I was absent from the meeting. So I still feel very strongly that we shouldn't have that under B, the second paragraph. So what I was envisioning is that So B would say, if the board modifies or rejects the DPA's findings and recommendations, the director shall prepare and electronically submit a written findings draft to the hearing panel for review. If any member of the hearing panel seeks to make substantive changes to the draft, the panel shall be reconvened, blah, blah, blah. So what I haven't felt comfortable with is not knowing if I'm on a panel member and we each get a draft, but I don't see what they're saying, they don't see what I'm saying. I don't think that's a good way for a quasi judicial body to act when we haven't agreed upon what we are then conveying to the chief. So I don't think we should have an option that, this whole to avoid a Brown Act thing. I don't.
Well, that
think
option, that option, and I wrote this for you, Julie, trying to achieve what you were trying to achieve. And that second paragraph was just allows flexibility if we're running up against a deadline and we don't have time, and that's all. Because we're gonna aim for what's in section B first. We're gonna call you back. And so the other section will only be
Right,
applicable when the time is when it's not possible and we're trying to, reach our deadlines.
Yeah, I guess I personally don't like that and don't feel like it's appropriate. And we've got lots of other deadlines where we have deadlines. But again, what I was envisioning is that the director prepares and electronically submits written findings to the hearing panel for review. And if somebody says, oh, there's a typo here, or it should be this thing, we don't need to reconvene the hearing panel. But if somebody's making wants substantive changes, then I think we shall be reconvened. I mean, I don't think it's any big deal. You have 1 hour.
I think it's a timing issue.
What if somebody that's on the hearing panel goes on vacation, right? And so you can't reconvene the hearing panel. Then what?
Maybe they're not even they're providing edits. If they're on vacation, it doesn't even come up. It only comes up if, like, say, Cheryl, you and I are on a hearing panel and Kathy prepares a draft decision and we say, well, yeah, but I also would really like this point to be made. And then you say, I want X point to be made. I don't know what you said. You don't know what I've said. And so we haven't agreed upon a decision as the body. It doesn't come up if it's minor. It doesn't come up if the other person is on vacation and isn't even, responding with substantive.
No, I'm not saying the other person's not responding. They responded. They responded, but they responded written to Kathy. Because it's not possible to reconvene the panel. So they're trying to give an option that if it's not possible, what happens? And just like Byron said, the goal is to do B, the first part of that.
To do the first part, yeah,
which is reconvene the hearing panel. But if it's not possible, the only other option to achieve what you're trying to get to is for the director to send out something individually to each hearing panel member, and individually they have to respond back, because otherwise it's a violation of the Brown Act. So that's the only other way to do it. So
I guess I'm not sure why me seeing somebody else's comments, why is that a violation of the Brown Act if I don't then engage? Say I just see what you told Kathy, you see what I told Kathy. Why is that a violation of the Brown Act for us to see each other's comments on a decision that we're supposedly rendered?
Well, what would be the point of seeing those comments?
right. That's not a violation, but then you can't do anything.
Well, that's what it says, to avoid.
Yeah, but what would be, okay.
Who shall not share the comments? I mean,
what would you do with seeing the person's comments? Because you can't do anything, right? You can't do anything. You can't say anything. You can't respond to it. You can't do anything.
Well, you can change your.
Mm,
I'm just asking the question.
I think when people see each other's comments, I mean, it can result in a change in someone's position. I mean,
But if that happens, now you're violating the Brown Act. Because
Yeah.
if you change your position because you saw something that somebody else wrote, now you're in violation of the Brown Act. So that's
Well,
why I'm asking, what happens if you see somebody's comment?
right, you can't do anything about it. And
Can't
I
do
don't think
anything.
I don't think your position would change. That would be pretty drastic because you've made a decision at the hearing. So it's just a matter of how are you going to articulate the basis for your decision, right?
Right. But I guess what I'm saying is, even if you saw what the other person responded back to, you can't do anything about it. You can't say
That's
anything,
right.
you can't do anything,
Oh, I see. Yeah. I see what
recommend
you mean.
anything,
Yeah.
you can't do anything. You just
Right.
see. So what's the point of seeing it? I mean, what will you do with it? I hear you, I see.
Yes, I just find this I have a strong feeling about it, but if nobody else does, but I still would like to include the language that I'm suggesting, and I can send it subsequently
Okay.
and we can discuss it at our next meeting.
Okay.
Julie, I don't quite understand. I don't know, the hour is late, I'm not focused well maybe, but I don't understand what part of these two paragraphs you would like to see different.
I don't think we automatically need to
No, I
convene.
did put that in there, Julie. If the hearing panel desires, like they don't necessarily have to reconvene. It's going to be their decision because it may be something very minor, and the board will make that determination whether or not.
Not minor, but straightforward. Right? Isn't that what you meant, Byron?
But this doesn't
Oh.
even say that the director shall provide a draft. So again, is it okay if I just propose some
Sure.
Yeah,
language
Sure.
and we can go over?
Yeah.
Okay.
Yeah. Okay, any issues with C? Oh, it's almost 9 o'clock, by the way.
How about if we finish with C and then end on M or L or whatever that is? I don't know what that
I
is.
think it's now L.
I thought we were gonna try to get through it.
Oh,
It-
okay.
What do you guys feel?
I don't
mean,
remember. Were we? I couldn't
You guys,
remember.
Talking about
and I-
longer, I
Did
don't
we
know.
say
I'm
we
not-
were gonna meet for 3 hours tonight? I don't remember. I could be.
You guys said 3 hours, but that's your call.
Okay.
You did say
Oh,
3
no, I
hours.
can do it. I can do it if that's
I
what.
can
someone,
do
if
it,
we
How about,
promise that we
about-
can get through to the end,
How
Right.
about
You
we
guys
move
promise?
halfway?
the next
How
hour.
about, how about another 30 minutes?
Yeah, how about that? How about 9:30?
That's fine.
Okay, let's see how far we go. So
I
what
need-
page are we on now?
I don't,
19.
we're on section L and I'm going to take a break. Please carry on.
Okay. So do you guys need to use a take a bathroom break quickly? Anybody?
Yeah, let's take a
Okay.
2
No,
2 minute
no.
break.
What?
Should we take a should we
Take a
take
break.
a
Let's go.
2 minute break?
Let's keep
1
going.
minute?
2 minute
1
break.
minute. 1
Yeah,
minute
but-
bathroom break.
Sure, investigator Norris and others can go on ahead. I think
We'll finish this without them.
Yeah, go ahead, Byron.
Wow, tough.
It's open.
Wow.
No, I can't
Army.
leave.
tough crowd. They'll come back in a minute. So 9:03, just come right back.
So Mike, did Mike leave?
I'm here. Yes.
I was just heard about that tragic suicide at Berkeley High.
Yeah, it's very unfortunate.
Just
Um,
awful.
Yeah, we're recording, just remember, but yeah, it's
Yeah.
there's lots of stuff going on about it now. It's very, very challenging. I think with the pandemic, everybody in general has had a lot of it's like substantial anxiety and depression issues and mental health in general. And then you can imagine with students being in school the whole time. So just to remind everybody that we are on recording.
Yeah, yeah.
What about Calavita? Were you gonna make a comment?
No, I didn't think it was at the high school. I thought it was at City College or something.
No,
Oh, it's a high school.
It was a high school student. It's very sad. And then on top of that, today we had the lockdown at Cal. I don't know if you guys heard about that. Yeah.
No, I didn't.
Were you there, Mike?
I was supposed to go to class in person, and that was canceled. And at first I was going to do a Zoom lecture, and then I thought that would be too stressful for the students, so just canceled the class.
Yeah.
Some of the BUSD buildings also had a soft shutdown. So, these type of threat assessment things are real. It was a credible threat. Things like this happen. So we do thank our law enforcement partners for the work that they do.
Yeah.
I'm back. Who else are we waiting for?
Kathy, but she said to go ahead without her, right?
I'm here.
She's
Oh,
here.
you're here. Okay, then let's go.
Yes,
Okay. Okay, Julie, you're up.
But is Lieutenant Montgomery back yet, though? I think because we said come back after a couple minutes. He's not quite back yet. Let's give him another minute. So we did talk about getting a bathroom break.
Here he
Okay, he's
is.
back. Great. So L, findings of Chief of Police.
Don't have anything?
Nothing here.
Okay. Okay,
Question
here,
about the tolling, the new one at the bottom.
yeah, so this is section 3 is new.
Yeah. Well, my question about that, I thought it seemed okay, but again, I always come back to parity. What if the complainant is unavailable, is sick or something?
I think this is another one where you can't have parity
Yeah,
because
The time, if the complainant is sick,
we can't,
but the officer has
Yeah.
rights when it comes to how a time limit on disciplinary procedures. So this is another one where I think you can have parity.
We've had situations where, I remember some years ago, 3 years ago, with the PRC where the complainant was sick and or unavailable. Oh, this is for the interview. Okay. Or no, it's for the hearing.
It's for
And
both.
it had to be postponed several times. Do you remember that, Kathy and Byron?
I do not.
I don't. I
it
believe you, I
doesn't
just don't
toll
remember.
it doesn't toll the time limit.
No,
No, it wouldn't toll. It wouldn't toll
No.
for that.
you
Yeah.
can't.
Okay. All right, then I think otherwise looks fine to me.
Yeah, looks good to me. Section 3. Contesting findings of decision when complainant filed with the police department.
This is all according to the charter.
Mhm.
I didn't have anything.
All right, thank you for that reminder.
I would suggest if this is a charter that we move on to whatever's next. I mean,
So is this something changed at 8?
No, I don't know why it looks like that. That's not
Okay.
new. Okay, there's your new section. This will become, I'll change the numbering. I gotta fiddle with the styles, but this will be number 5, informal complaints. And I think we talked
Right.
about this at great length, right?
And,
We
and
did, but now Kathy, just so
Oh.
you know, at said meeting under C, it says under
Oh,
section, that has to be changed to section Roman numeral 4. It's referring back to the,
yeah,
yeah.
I got it.
And that's all I have there.
Okay, that looks good.
That's the end.
The only
Well,
thing the only last thing, and I've probably raised this before, and I'm sorry if I don't remember what we decided, under complaint follow-up, which is, the second to the last thing. I remember it had come up before where there was a complainant and the concept is, well, maybe afterwards we could say, these are other resources or, right? Remember that discussion? So it isn't
Yes.
just a survey, but it's us telling them or staff telling them, the director, whoever, telling them, these are some other avenues for you rather than just, not sustained, exonerated, but we understand that you've raised some legitimate issues, but they're not going to be addressed here, but you could do X, Y, and Z. So do you guys remember that?
We did
discussion?
talk about that, and I thought we resolved to just not put anything about that here and leave that to staff.
We talked about it at our last meeting, but Julie wasn't there.
She wasn't? Okay.
Yeah, because the only example that we could think of was mental health services as one example, and it seemed that would be potentially insulting to
Well,
raise.
wasn't there something about parking? Remember there was a parking related complaint and
Yeah,
it wasn't mental health necessarily, but I think we had and direct the complainant to potential outside services or just something like that, but
yeah, Miss,
But-
Miss,
but
I
does-
think
does-
I thought it was
but
Miss
does that
Aguilar
need
had
to-
raised the
Yeah,
concern
but does
about
that
how they're for that.
But does that need to be here? That's something that the board can discuss with the director, and does it need to be here?
Yeah, I have a problem with the shall language.
Shall invite the
Right.
subject officer complainant was as opposed
well,
to
and
exit the survey.
may
Okay.
direct the complainant to other relevant services. But anyway, if people don't agree, I will let it go and make a note to myself never to raise it again.
So do you want to change ODPA staff shall to ODPA staff
No,
may?
no. It's fine the way it is. It was
Oh.
just, I had a problem with shall direct to resources.
And it could
Oh, I
be
see.
and may
right.
direct the complainant to appropriate, to other resources as appropriate or something, but again,
Okay.
if people
I
don't
think
agree
that
with
could also be up to, that's the kind of thing that could be handled informally since they're going to be doing an interview, it looks like in some cases anyway,
Yeah.
then maybe they can do that on a case-by-case basis if they want to.
Okay.
Mhm.
Okay.
Yeah.
Kathy,
Sounds good
those
to me.
numbers have to be updated to 6 and 7.
Yeah,
Roman-
I'll do that. I'm just afraid of touching it right now. And
Yeah.
and it's auto numbering and it could go wacky at any time.
Yeah,
I will change them. I'm
I
gonna
think
go
we
back.
got through it.
We
Okay.
finished. Wow.
Yep. Good job.
There was something
And
up
we-
here that staff had. Oh, here. Yes, we had this language, but we didn't have it ready for you last time on handling confidential information. So the original language had just been built upon because we had to add a provision for electronic, and then it got really wordy. Because of that, it was really wordy. So we think we've streamlined it. But take a look and let us know.
That seems fine. It's a long sentence, but okay.
It is.
Right.
Yeah. It is a bit long, but and that's what we've been doing in practice, right?
Mhm.
I guess you want to be specific. Is that the point, Director Lee?
Pardon me?
Specific and succinct.
Okay.
Yes.
Sure. Okay.
You could, if you wanted to, break up the sentence and is no longer needed, and then board members shall inform.
We can
Staff.
break it up. We can break
Yeah,
it up.
yeah,
We
I
had
don't-
actually considered doing that. If you think it works better, we can break it up.
Yeah,
I have no
I think that's
problem.
probably best. Okay.
I mean, not now, but we could break it up.
Yeah.
That looks
That's
good
great.
to me.
Okay.
Do people, should I go ahead and put in email my suggestions in case anybody cares? They were things like representatives, plural, and just, because my other option would be for me to call Kathy and it'll show up in the next version, or do people prefer that I put it in an email to everybody?
If it's
No, I think
grammatical, if it's grammatical, I think you can just send it directly to Kathy. If it's just grammatical.
Yeah.
And then
Email's
in the
better.
email. Yeah, that's on record, then she can refer back to it if she needs it for memory.
Exactly. Thank you.
Okay.
Okay.
That looks
Great.
good. We've gone through this very closely. I think we should be proud of ourselves of all the work
Really?
we've done. Yeah. And it will get, you guys know it will be picked apart when it goes through again. That's just how it's going to be. But we will also hear from Lieutenant Montgomery and get additional feedback from the police department on the draft. And then when it goes in front of the full board, we'll have to give them as much specific commentary as we can, because they're coming at this from no awareness to suddenly jumping right into a pretty complex document.
Wasn't Kathy talking about maybe doing it over 2 meetings? Because
We might have
remember we
to.
were saying this is so dense that it's hard to imagine that the board's going to be able to get through it in 1 meeting.
But I think we also have to have actually a strategy for,
Yeah.
I mean, they're not going to be able to go through it the way heaven forbid they go through it the way
Sure.
we have gone
Yeah.
through every single paragraph. I think that we should send it to them, well ahead of time and
Yeah.
point out the sections, especially where we've said, discuss it full board.
Could it be like a
Yes.
memo even on those?
Yes.
It'll be flagged in the comment and a brief memo.
We had
Yeah.
already talked about that, and I'm
Yeah.
prepared to do that because I think that's a great idea, that we need to help them identify some of the more difficult sections,
Yeah,
and maybe just highlight some of the changes that have been made, significant changes from the interim regs, such as the way in which complainants and officers are in the hearing and things
Yeah.
like that.
yeah.
And the board.
Maybe we don't
initiated.
need the next 2 meetings. We have 2 meetings scheduled, right?
We can always cancel.
Okay.
We do
You're
need
talking
to,
about the regulations meetings?
Yeah.
Well, we
We
do need one with Lieutenant
with-
Montgomery.
No,
That
I
was-
know. I'm
Yeah.
just saying
No, no,
maybe
no.
we don't need the one after that. But
Yeah, we'll
see.
see. I plan to be so compelling that changes. may be-
Change the whole thing.
But we're gonna
We'll
have to
just-
start all over again.
all right, we'll just be bowled over.
All right, everybody.
Okay,
Okay,
All righty.
thanks,
we-
everybody.
Wait.
We saved 14
No, we
minutes.
need to make a motion.
Kathy,
Oh,
Kathy,
What?
the rest of the agenda?
are there any public members?
oh, that's
Public,
right. Yes. Good reminder.
Yes, there is one member of the public.
Oh,
If you
okay.
would like to speak.
Okay,
please
let me get the
raise your
timer
hand.
ready.
Use the Raise hand icon.
Hang on a second here. Timer.
I don't think you need the timer because no hands.
The person,
That's
has the
true.
person raised their
No,
hand?
I don't believe the person.
not
wants to
raised his hand.
Speak, so.
Okay. Okay, no need for the timer then. Great. And would someone like to Move to adjourn.
So moved.
Okay, no objections.
Goodbye.
Good night,
Bye. Thank you.
everybody.
Have fun the rest
Bye.
of your vacation, Baron.